Good evening, allowed to.
But today, this court has to rise a bit early. There's some important meeting in the second half. But we'll try to finish off the matters. Bring it. Yes.
May it please, Your Lordship. My lord, I beg to mention item number.
You like to give light to the night.
Item number 8.
I don't know. Light to 9 under Yes.
Lordship, item number 8 may kindly be adjourned. Your Honor. Maybe
8.
8, Your Lordship. Maybe taken on Monday, 27th, Your Lordship.
Motion matter where you are adjourning
Lordship, today some difficulty.
on a request made on behalf of the petitioner. Matter is adjourned to be listed on
27
20.
this month.
27 Monday will be difficult. Today is
Monday,
20.
Monday.
We'll have it on 29th.
Lordship.
29.
Devolve.
Wednesday.
The concern of the other side is to mention item that 39, 40, 41.
39 to 41.
39, 40, and 41. Can you allow 3 weeks time to file our affidavit logs? And for the respondent, central GST also.
Okay, what is your name?
The JP mode also. I'm appealing on behalf of Mr. SJP.
Okay. On a request made by the learned counsel appearing for the central GST, matters are adjourned by 3 weeks to enable filing of affidavit in opposition. Is there an interim order?
Interim is there.
Interim order, if any, stands extended till the next date of listing. List on, give a date. Today is 24th. 1, 2, 3. We'll have it on 18th of May. 18 May.
Wait, please, Lord, I beg to mention item number 45.
43.
45, Lord.
45.
We file the compliance.
What is
Lastly,
it?
compliance will be yet to be filed, Lordship. Lastly, compliance affidavit yet to be filed, Lordship. The matter
Okay.
will come up after 1 week.
Okay. What is your name?
US Bora.
Sri U.S. Bora Learned Counsel for the. Have to inform the other side.
Yes, Lordship. I will.
Sri U.S. Bora Learned Counsel for the petitioners has submitted that the affidavit regarding the dusty service is yet to be filed, and accordingly he prays for some time. Correct? Matter is accordingly adjourned to be listed on 6th of May to enable filing of such such affidavit. Yes,
May it please, Lordship. I beg to mention item 35.
35.
35.
Yes. What is it?
Maybe adjourned for a day. Conducting counsel is out of station.
You're for the petitioner.
Yes, Lordship. We have
Hmm?
taken consent from the other side.
Yes.
We have taken consent from the
Take
other
the
side.
consent. You are for the petitioner.
Yes, I'm
On a request made on behalf of the petitioner, matter is adjourned to be listed On-
6 May.
on 6th of May.
There is an interim order.
Interim order passed earlier, stands extended till the next date of listing.
Obliged.
Item 47 for withdrawal.
Lordship.
We have been instructed to withdraw this matter, Lordship.
Okay. Sri UK Decker, what is your name?
Lordship, US Bora.
US Bora, you are not there.
I'm not there. I'm appearing on behalf of Mr. UK.
Sri US Bora Learned Counsel appearing on instruction of Sri UK Decker.
UK.
Okay, Decker. For the petitioner, submit that he has instructions not to press this writ petition. Also heard Sri J. Hendik, Learned State Counsel. Para, writ petition is accordingly dismissed as not pressed.
Lordship.
Item 1.
May it please your lordship, my lord. The operative portion of the judgment is at page 28, paragraph 16 and 17. The state authority was supposed to dispose of the applications pending under section 23 of the revenue regulation.
Page 28.
Yes, ma'am. 28, paragraph 16 and 17 is the operative portion. May I read the paragraph 17, my lord?
There were a number of writ petitions. How many writ petitions there?
Two writ petitions.
Two writ petitions.
Yes.
Okay.
Both were disposed of by common judgment.
Yes. What was the direction?
Direction is at page 17, sorry, paragraph 17, page 28.
Please.
At the bottom, my lord.
The replication. Your application under section 23 was pending.
Pending, it was
It
not
was
disposed.
directed to be disposed of,
Yes, my lord.
not done.
Not done.
Heard. Dr. H. Hamo, learned counsel for the petitioner, who by means of this application has alleged willful and deliberate disobedience of the judgment and order dated 26/3/2020. No. What is the order? Judgment order dated
Order dated, my lord, 26 March 2025.
20?
26 March 2025.
What have you written in your cost title? Why do you make such mistakes? Cost title, first page. Order dated 26/3/2023.
Oh, so sorry, my lord. It should have been 25. Sorry, my lord. Page 2.
26/3/2023 passed in WPC, two WPC. Huh? The learned counsel has also drawn the attention of this court to the representation submitted requesting for compliance of the order in question. Para, let notice be issued, returnable on 25th of May. Let steps be taken for service of notice upon the respondent by speed post petity, steps within 2 working days. Respondents, sir. 2 working days.
I'm deployed. Well, may I make the corrections that date?
Correction by hand would not be possible. It has been entered into a CIS. You have to make an application.
Well, do it.
I mean, very good. 25. 25. Contempt करने क्या हुआ?
May I please?
Yes.
Lordship, others are supposed to take instruction.
That's it. They have received the instructions today. So can they fix time litigation?
We issue notice.
No, Lordship. No. Can they?
Why notice is not to be issued?
Lordship, can they notice me go today?
That is what we are saying.
Lordship.
You are objecting to issuance of notice. Why, madam? You don't want the court to do any cases. You said no.
Can they?
Sound to look communist. Yeah, what is your case?
Lordship, the petitioners are executive members of the Burago Gaupanchayat. And Lordship, an executive meeting was held on 10/12/2025. And subsequently the meeting was postponed due to poor presence of members. Thereafter, Lordship, no meeting was ever held and the resolution was passed. Under
You are
the-
agreed by the list prepared
No,
for distribution.
Lordship, the meeting was not held without holding meeting. They passed the resolution, Lordship. In the resolution, Lordship, it is the list of the 15 Finance Commission, Lordship, Annexer 2, Lordship. These schemes are come under the resolution. This was passed. These were passed.
What is your name?
K. Islam, Lordship.
You are not on record, you are there. Khairul Islam.
Yes, Lordship.
Heart free Khairul Islam learned counsel for the petitioners. Full stop. As per the facts projected, the petitioners are executive members of Huragaon Gaon Panchayat in the district of Murigaon. Full stop. Their grievance is against the preparation of a list without holding any executive meeting under the 15th Finance Commission. Full stop. Para, this court wide earlier order had directed instructions to be obtained. Para. Let notice be issued, returnable on on 29th of May, 2026. Miss N. Bora, learned standing counsel PNRD for
1, 2, 4, 6 and 7.
how to is finance department.
Lordship, 1, 4, 6, 7.
1, 4,
6,
6 and 7. Madam RM Borua, on behalf of Chalia, or you are a standing counsel? On behalf of Chalia, RM Borua for 2 and 3 SS Roy. And what about the others, 7 and 8? Secretary also?
7.
7 you have taken, 8. Yes, 5 and 8, 5 and 8 speed posted ready. 5 and 8 speed posted ready. No? Extra copies, 5 and 8 speed posted ready. Okay.
Would like,
Again, today,
May it please your lordship.
Yes, yes.
instruction was sought for doctor received the instruction. Notice.
What is the matter, Mr. Borbhia? Mother Bhia? Your mother Bhia?
Yes, yes, sir, lordship. Your lordship, the predecessors of the petitioners were originally the tenants of the land, which then under the Act of 1951 came under the ownership of the government, your lordship. The Act of 19.
Zamindari Act.
Yes, your lordship. Thereafter, the said land was sold, your lordship, by the tenant. It was sold by registered deed dated 6/2/1983.
You had sold the land.
Actually, the original tenant had sold away the plot of land to the masjid. And
Who are you?
lordship, we are the
You are the
management
purchaser.
management committee of
Purchaser
lordship.
of the land from the tenant.
We are the management committee of the masjid, your lordship. The registered deed has sold away the land to the masjid, and the said record of the masjid being the tenant in the land was recorded in Chitta certificate annexure to page 18 and 19, your lordship.
Now, what is your
Your lordship, by virtue of section 4 of Assam landholding adoption of relationship under the Assam Land and Revenue Regulation 1886 in the Acquired Permanently Settled Estates Act 1974. Section 4 of this
but
act.
can the tenant make transfer of land?
Your lordship, the section
When
4.
the Jamindari Act had given benefit to the tenant of allotment after taking over the land, whoever is in possession, can you thereafter transfer it?
Yes, your lordship, under this act,
Mr.
section.
Roy?
Your lordship, section 4 of this act has rendered the tenant as status of landholder, your lordship. Section 4 of this act.
Which one?
Lordship, I have to copy.
You have quoted that. I
Yes,
think you
your
have quoted that in the
Yes, your
petition.
lordship. Page 7.
Page 7.
We have only quoted the relevant portion, your lordship.
Broad land of the person. Where is the power to transfer?
Lordship, they by the virtue of section 4 of this act, they acquired the status of landholder, your lordship.
Yes.
And as landholders, they have then.
See, you secure that status because of a particular act. Will it confer the right to make further transfer? Is it the objective of the act? What is your instruction?
Which was made in government land. Was amendment. Thereafter, lordship, we are awaiting further instruction from the revenue circle, lordship, that how this the circle of it has been changed.
Okay. Let us issue notice then. Okay. Third,
IS Mazhar.
IS Madhur Learned Council for the petitioners. Full stop. The projected case is that the predecessors of the petitioners were tenants under the Jamindar over the land in question. Which was transferred to the petitioners via a registered deed of the year 1983. Full stop. The apprehension, the grievance is against the apprehended move of the government. No. The claim in this writ petition is for issuance of regular patta to the petitioners. Full stop. Para. Let notice be issued. Returnable.
Your Lordship, if I may, Your Lordship, there was a order passed in 6th March 2026 in a similarly situated case by Your Lordship, where an interim order was passed maintaining the status quo. We seek for similar prayer.
But what is the prayer in that petition? In that petition, you were apprehending eviction. Here you are seeking issuance of patta. There is an interim prayer, we have seen it.
Your Lordship, in this one also, we have an interim prayer for apprehending eviction. Your
That we have seen, but your primary prayer is for issuance of patta.
Lord.
Your eviction, your apprehension is based on what? Let us see your averments, that there is a move to evict you.
Your Lordship, no acquisition or compensation has taken place, and despite representation dated 11.
Now, where is the statement regarding an imminent apprehension that you would be evicted?
Lordship, it was the apprehension was created based on the.
Where are the statements? Where have you pleaded?
Lordship. Lordship, kindly come to page 8, para 4, Your Lordship. Towards the last part of the para 4, we have stated it, Your Lordship,
What have you stated?
that after the representation was submitted and without any result,
How have you verified the averments? An apprehension of eviction, how have you verified the averment?
So it was, Your Lordship, it was just.
How have you verified in the affidavit? There is an accompanying affidavit of the writ petition.
Lordship.
How have you verified those statements? Kindly come to the affidavit. Page 12. Paragraph 4 is true to what? To your knowledge. From records, if you are seeking that your eviction emanates from some records, you have to produce the records.
Lordship.
You have to be careful, not filing just like that. Affidavit in a writ petition is most important. There is no scope of any further adducing of evidence or cross-examination. So it's the documents, pleadings which are supported by an affidavit. Don't take it lightly.
Lordship.
Other than the affidavit, we have nothing. We have to deal entirely on the affidavit. Okay, Master. That's what question. This court had earlier directed the Learned State Council to obtain instructions. Let notice be issued returnable on returnable on the on 25th of May 2026.
For 2 and 3.
With for one, Miss Ann Bordwell and Standing Counsel, Revenue Department for one, whereas
2 and 3 and
the SS Roy, State Council for 2 and 3 extra copies. You file an application, we'll consider,
Lordship.
not like this.
Much obliged, your lordship.
You take this back.
My lord, because my lord, I have annexed the judgment of the family court, and this is admittedly, this says that I would say.
No, see, judgment of the family court would be one of the relevant factors, but will it mean that even a joint account has come to an end?
This is not a joint account, this is the account of the father.
Then how, the operation is by how? How is it?
By my mother, my lord, who is the divorcee?
How is it done?
My lord, the mobile number of my mother is linked with, my lord, bank account of the father. Lordship may kindly page 35, my lord. This is the bank mobile number, which is in the name
Let
of
us see the
the
bank account. Bank account.
bank account. I have not, my lord.
Let us see the account details.
Yes,
Where are the account?
my lord,
details?
in the legal notice, my lord.
No, account details. The passbook, anything.
Passbook I have, I don't have the passbook.
Something
Passbook is
you
the
have to-
mother. With her mother.
Some details you have to give from that. This is
My
the
lord,
account.
details of the.
Where? Which document?
My lord. Page 32, my lord.
32 is your legal notice.
Legal notice, wherein I
We
have,
want a document to show that this is a bank account belonging to the father of the
this is
petitioner.
the admitted fact, my lord.
No. Admitted will not.
Lordship may kindly see name of the account holder, account name, CIF number, everything I have mentioned.
This is
my
your averment.
My lord, lordship may
Either in a writ petition or in the legal notice. That is what you
kindly
have
see the
stated.
reply to the legal notice, my lord. Reply to the legal notice, my lord. That is admitted fact, my lord.
What is there?
Page, it start at page 37.
Hmm.
And the operative portion of the reply is page 39, paragraph 3. The saving bank account bearing number so stands solely in the name of Dipen Sharma, who is the exclusive and lawful account holder. Any change, updation, blocking, modification, operational alteration in the said account can only be effected upon by written request duly signed and authenticated by the account holder
How
himself.
much amount does it hold? Any idea?
My lord.
How much is amount the account is holding?
It is, my lord, there are rent of monthly rent of about, my lord, 70 to 80,000 that immediately withdrawn by the mother. And it becomes, my lord,
Mr. Boragohan, what can be done?
Lordship had to obtain instruction regarding the balance part, and regarding the operation part, he had made a prayer, says the registered mobile number of the bank account. This can only be done in the request of the bank account holder, not third person.
No, here is a peculiar case where the account holder is in a vegetative state. But the problem is that there are no, where are your medical documents? No medical
no,
documents.
my lord.
At least furnish some medical documents, maybe earlier medical documents, not.
These are also with her, my lord, mother.
How is it possible?
My lord,
A person is in vegetative state, you do not have a
She
document.
used to even see after divorce, she even used to reside in the house of the,
No,
my
Mr.
lord.
Sharma,
This is the problem.
Mr. Sharma, is it impossible to get your father seen by a physician and give a certificate? It's not impossible.
My lord, without diagnosis, without, my lord.
Some physician will have to be, he has to be taken to some physician. That much you have to do.
May I pay one thing, my lord? If your lordship, my lord, in the considering the peculiar nature of the case, advocate commission or whatever inquiry commission, my lord, if you're direct
First
to
you,
visit the,
first you, the advocate is not a physician.
no,
You first make it a
to see the
private.
condition of the, my lord.
First make it a private case. You can arrange for a physician to come to your place and give at least one document. Then we'll proceed.
Without diagnosis, they refuse to do it, my lord, doctors.
Because there's an order from this court that
That-
you are
that
given
I-
time to file additional affidavit and then enclosing medical
That
documents.
I have, my lord, requested to, before this to honorable court. to
Then
file-
you file
lord,
affidavit, file affidavit.
But when my lord, instructed my client, see, my lord, said, my lord, without my lord diagnosis, my lord, doctors refused to,
Then at least you have to put that on record, and whether that will be accepted by the court or not, that's a different matter.
my lord.
But you need to make an endeavor. There's a clear direction on 7.4.
Yes,
On
my
your
lord.
request,
That's true, my lord. That's true. That is why, my lord, initially,
Sri D.K. Sharma, learned counsel for the petitioner, by referring to the order dated 7/4/2026, has submitted that the additional affidavit could not be filed as the father of the petitioner could not be examined by a physician. Full stop. He accordingly prays for some more time to full stop. Let the developments be put on record by way of an additional
my
affidavit.
lord,
If it's impossible, then also you have to state it on records.
my lord.
We fix a date.
Eh,
Sri Buragohai, H.
My
Buragohai,
lord- my
learned
lord,
counsel for the bank is present. List on how soon can you get back, Mr. Sharma?
2
Today
weeks,
is
after
24.
2 weeks, man.
We'll have it on 8th,
Thereafter, my lord.
8th,
Thereafter,
after 8th,
after it,
then 11th,
my lord.
11th.
My lord, in the meantime, my lord, not to operate the bank account, my lord. in the
That will
meantime.
be
My
difficult.
lord, my learned friend may be instructed, my lord, not to withdraw the
See,
amount, my lord.
he has made his stand very clear in the reply to the legal notice.
My lord,
We cannot force him. At least you have to produce one document. From the legal notice reply, the details of the account, we have almost come to a certainty that it is a single account holder.
yes, my lord.
That part is hold, but the other part, you bring some record, we'll try to resolve it. Okay. 11th.
God bless.
Mr. Borago, you also try to explore in this kind of situation, what can be done?
So there is a case, election, and next day I'll place it.
My lord, in fact, the bank authority has sent a person to, my lord, see the condition of the father. That has been admitted,
What is that case?
Your Lordship,
that they have stated in the affidavit in opposition.
2023, 1 GLR.
Our Gauhati High Court case, yes, that we know. That we know.
I am Das.
Okay, yes. Okay.
Obligement.
Item 5.
Item 5, yes.
My lord, my lord, petitioners are the matter the legal heirs of the my lord, the original pattadas, my lord. The land of the being patta number my lord 30 and the dag number my lord 383, the Lakhimpur district. My lord, the respondent number 4 also my lord, one of the my lord, the legal heir of the my lord, the original pattadas, my lord, one of the original pattadas, my lord. He my lord, what happened, my lord? He unilaterally my lord initiated the partition proceedings, my lord, before the circle officer, my lord. And circle officer, my lord, issued my lord expert order, my lord. In
But
favor.
that was of 2020.
Yes, my lord.
Partition order, how do you challenge in a writ proceeding?
Then, my lord, what happened, my lord? Petitioner filed.
Mr. Roy, partition order,
Okay, wait and appeal the deputy commissioner, thereafter. It's
My lord,
the board is there, how do you
Madam,
invoke
can you see the
227 or 226?
Deputy Commissioner order, my lord, on 4/1/2024, my lord. That record was not traceable, my lord. It is, my lord, only my lord, my failure of the my lord, the exercise of the my lord, the Deputy Commissioner, my lord, petitioner came before the not before.
Deputy Commissioner is not a court.
Yes, my lord.
How do you invoke
My lord,
227?
my lord, my lord, the impugn order, my lord, on 4/1.
Now, how do you invoke 227?
That is true, my lord. There
You
is-
said in the synopsis, it's a petitioner 227 seeking supervisory correction of the
Lordship.
jurisdictionally void ex parte order. Order is by partition order, is by Deputy Commissioner. It's not been a court.
My lord, 147, my lord, kindly see section, my lord, in the Assam Land Revenue Regulation, my lord. 147.
Bar.
Yes, my lord, B, my lord, appeal shall lie under the regulation as follows, my lord, to the Deputy Commissioner from orders passed by a sub-divisional officer.
Okay.
So accordingly, my lord, petitioner file also, my lord, the one, my lord, the bill, my lord, before the Deputy Commissioner, my lord. That order, my lord, till today, my lord, not, my lord, disposed of, my lord, by the concerned Deputy Commissioner, my lord. So that is why, my lord, this order, my lord,
How do you invoke 227?
Annexer G, my lord, kindly see, my lord.
Yes, Mr. Roy, what do you say?
That is a notice here, go, my lord.
Hmm?
And RTA application also filed with the petitioner, my lord.
That is a different course of action. You can challenge it in an appropriate proceeding.
But it is, my lord, not the, my lord, the 117, my lord. It is, my lord, the petition filed by the petitioner before the circle officer as well as, my lord, subsequently, my lord, before the deputy commissioner. On that basis, my lord, the miscase was registered, my lord, that is 1120, my lord. And on that basis, my lord, 4124, my lord, the deputy
See,
commissioner.
4/1/2024, the deputy commissioner district commissioner has said that the records are not traceable.
Yes, lord.
Well, what can be the remedy now?
He is not challenging this order of lordship, he is challenging the annexure C
My
57.
lord, yeah, my
Oh, 4/1/24 is not challenged.
challenge, my lord. It
Where?
is main order, main stay, my lord.
Yes. Yes, but
The connivance with the, my lord, the circle officer as with the respondent number 4. Only, my lord, this case
Difficult,
notice will go.
difficult. I heard three. And the learned counsel for the petitioners who are aggrieved by an order dated 4/1/2024 passed by the district commissioner Lakhimpur in miscase 11 of 2020. Full stop. The grievance also extends to the order dated 21/5/2020 passed by the circle officer, not Lakhimpur Revenue Circle, in a partition granting ex parte Batwara oblique partition. Whereas Roy, the London State Council, has however raised an objection questioning the maintainability of the writ petition. Para, that notice be issued, returnable on on 25th of May. We SS Roy, Learned State Council accepts for. What about one revenue? One revenue department. 2 and 3 SS Roy State Council. Extra copies 4, 5, 6, 7, and 8 by speed postal release. Steps within 2 working days.
My lord, the justice service may. My lord.
First, you take steps. Let us
Sure,
speed
sure.
postal release.
Lord. Obliged.
The aspect of maintainability of the writ petition is however kept open.
Obliged.
Item 6. Yes.
Your Lordship, this is a case where a very small amount of 310 is disputed in nature, but the petitioner's entire account, which consists of 18 lakhs 60,000, has been put on debit freeze. The petitioner is a small business owner, Your Lordship. This business was originally her husband's, but later, after his death, it was transferred to the petitioner.
Which bank, madam? Which
Lordship,
bank?
HDFC Bank, Your Lordship. Your Lordship, this is the sole source of her livelihood, and this is still under debit freeze. Your Lordship, in the ordinary course of 2 transactions, one was, Lordship may refer to Annexure 3. One was transaction of 110, out of which the disputed amount is 110.
Yes, Mr. Doctor, you appear for whom?
number 7.
7 is whom? Union of India.
It is my consideration that the matter is under the domain of the other response. Bank.
Okay, where is the order, madam, by which your account has been frozen? Page?
Annexure, my Lordship may refer to Annexure 2, wherein
Yes.
the bank has replied to
Page 31. Page 31.
page 31, Your Lordship,
Yes.
wherein the bank has replied to our email stating that the impugned action was taken by the because of Gujarat police, and apart from that, no such information was given.
Which is your branch?
HDFC Bank Jorhat branch, Your Lordship.
Jorhat branch.
Yes, sir.
You do one thing, your clients are from Jorhat.
Yes, your lordship.
You served the bank, Dusty. We'll have this matter on Wednesday next.
Lordship, I have served, I have emailed the bank as well as Gujarat police, but no recourse was given to me.
That was prior to filing of this petition.
Yes,
You
lord.
serve a copy of this petition, Dusty, and but serve and intimate that this matter will be taken up on Wednesday. We'd like to pass some orders in their presence. We have been passing certain orders, securing some amount and letting the order, the account to be activated. Okay.
Lordship,
Can you serve by Wednesday?
I'll do that, lordship.
What is your name?
Huh?
Your name?
Lordship, may please pass any direction to unfreeze the account for the time being.
Without hearing, it will be difficult. That is why we are giving you an extra, this thing, by Wednesday. What is your name?
Advocate Vashiti Chiran Besbura.
B?
VAASY.
No. Give your initials. Besburo. B. Besburo.
B Besbura.
Heard, miss. You're not on record, madam.
Ma'am, lordship, my name is in the Wakalatnama.
Heard, Miss B. VC Besburo, learned counsel for the petitioner who is aggrieved by the action of the respondent bank in freezing her account. Full stop. It is contended that the dispute is of a meager amount of 310, with which the petitioner has no connection, in spite of which the entire account has been frozen. What's the para? Since the petitioner has an interim prayer, this court is of the view that the presence of the bank would be necessary for passing such interim order. Para. Accordingly, this court permits the petitioner to serve the respondent HDFC Bank in their, you can serve at Gauhati also, wherever you want. When do you want to serve? Where do you want to serve, madam?
Gauhati, we'll do that in Gauhati.
Jorhat and Gauhati, in their office at Jorhat, as well as the journal office at Gauhati. Within bracket, respond numbers 1 and 2. Full stop. Let the petitioners would also be at petitioners is also required to enclose a copy of today's order so as to enable the bank to appear on the next date. Full stop. Let the next date be fixed for motion on 29th of 29th. But you take steps immediately. We'll try to give you the order within the course of the day. Okay. Sri A.K. Datto, standing counsel, London CGC is present.
I can serve. My pleasure, lordship. Matter pertains to my lord fake traffic salon link resulting in foreign transaction originating outside India, my lord. Petitioner was traveling in his own car, my lord, and received an SMS, my lord, that is at page 34, my lord. And he paid, my lord, 500, my lord, but amount was deducted 2,96,368.
From whom? From
That
your
is-
account?
Yes, my lord.
Deducted by whom?
Deducted from credit card, my lord.
On account, what account? By means of fraud?
Yes, my lord, cyber fraud, my lord.
Then you had complained before the ombudsman?
Yes.
And what is the result of the
Page
ombudsman?
60, my lord.
60.
60, my lord.
What is it?
They are saying is that, my lord, no service deficiency can be attributed to the bank.
Okay.
But, my lord, within short time, my lord, I have informed the
Okay. Heard Sri B.K. Sharma, learned counsel for the petitioner who is aggrieved by an order dated 24/3/2026 passed by the RBI ombudsman, whereby the complaint of the petitioner has been rejected. Full stop. As per the projection made, the petitioner is a victim of cyber fraud, whereby an amount of rupees 2,96,368.96 has been debited from his credit card
yes, my lord.
in euro currency.
Euro currency, like, lordship.
What did you do?
Now, we have already made complaint, my lord.
No, how come it is debited in euro currency? You are making some transaction.
Yes, my lord.
What?
500 rupees I paid, my lord.
To? For what?
Traffic challan, my lord. Page 34, my lord. Kindly see, my lord.
Traffic challan.
Yes. $500 I paid, my lord. But a notification received from the bank, my lord. That amount was deducted 2,96,000, my lord. Immediately I informed the.
On receiving the SMS, you have
Yes.
paid the.
Yes, yes, my
You
lord.
need to verify. These are very common nowadays. We understand that you are a victim of circumstance, but it has been circulated to such an extent that you should be very, very careful. Traffic challan, all these fraud messages. Every day you'll get.
Kindly, my lord, page 31, paragraph 31, kindly see, my lord.
Credit, for his credit card. It is submitted that the petitioner had received an SMS indicating, alleging violation of traffic rules, in which a link was given, and the petitioner had bona fide opened the link and paid rupees 500. Whereafter, immediately the debit was made of the amount mentioned above. Full stop. Have you filed any complaint to the police?
Yes, yes, police SCP report is there, my lord.
Okay. Let notice be issued, returnable on. Mr. Hendrick, something has to be done. This is so rampant now. It might happen to anyone. It's happening on a daily basis. We will not know how many people are being duped. Returnable on 18th of May. Who will take Union of India? Mr. Doctor? Union of India, you are AK Medhi. PK Medhi for CNGC for 3. And 5 and 6, I think, Mr. Hendrick.
I appear on behalf of
5 and 6, J. Hendrick, State Council, extra copies. Steps for service of notice of 1, 2, 4 by speed post PTD. But you take instructions, Mr. Hendrick. Something has to be done. This cannot be an isolated case. There will be many more cases.
Okay, sir.
Item 9. Item 9. Yes,
May I please, your lordship?
yes.
My lord, the petitioner has already been evicted, my lord. Already been evicted.
Yes, Forrest, madam. Already been evicted, so what do you want now?
My lord, we want that we should be, my lord, rehabilitated as well as, my lord. There is a, my lord, series of petitions being examined by this honorable court. There is direction had also been issued, my lord, to provide the basic amenities. Because now, my lord, we are settling in a very deplorable, in a camp condition, my lord.
Where is it? Which district?
Yes, yes, my lord.
Hojai district.
Hojai district, my lord.
Okay.
My lord, may this honorable.
Madam, you take instructions. Okay. Do you have the number of the earlier cases?
Yes, yes, I have annexed, my lord. I have
Okay.
annexed that.
We'll issue notice and we'll tag with those cases.
My lord,
And in the meantime, we obtain instructions.
my lord, may I pray, my lord, some interim order, my lord.
Like,
Directing, my lord, this type of, my lord, the similar order I have annexed, my lord. While issuing notice, this honorable court passed similar orders, my lord, may be pleased to find. We have annexed, my lord.
page,
My lord, page starts at 128 and the operative part, my lord, is at page.
page,
Yes, yes, my lord. The operative part started page 138, paragraph 16, my lord. Page 138, 139, my lord.
now take instructions. We'll consider his prayer. Heard 3, A.R. Bhuya, Learned Counsel for the petitioners. Full stop. The petitioners are aggrieved by their eviction from lands under deposition
My lord.
on the allegation that those lands are forest lands.
No, my lord, yes, but we
On
have
the
claimed
allegation.
that it is patta, my lord, but they are claiming.
But
it is
the
forest.
petitioner claims that those lands are patta lands
My lord,
and outside the purview of forest land.
my lord.
Full stop. He has also, the learned counsel has also submitted that similar petitions are pending in this court, including WPC
888, 26, my lord.
88826 para. Let notice be issued, returnable on 25th of May, 2026. Chief Secretary, Mr. 16812 লিখিছা গোটেইকেইটা GND, then revenue 2 Eviction. Then Madam Kolita, M Kolita for 3
9 and 11.
3 4 9 and 11 and okay B Deka Standing Council Elementary Education 14.
My lord.
And what about the public health engineering? You have already taken. Forest and engineering you have okay taken. And let extra copies be served.
5 and 7 I'll get in health.
Health
Yes.
H alia 5 and 7. The prayer for interim order with regard to providing necessary amenities of to the petitioner would be considered on the next date on receipt of instructions. Get the instructions where they are they been provided any amenities? Okay.
My lord. Obliged.
Item 10.
May I please, your lordship? In item 10, in this item, your lordship, pursuant to honorable court's direction, your lordship, which is at page 35, your lordship, we submitted our individual claims, your lordship, to the principal secretary, your lordship, Moreland Territorial Council under section 64 of the 2013 Act, your lordship. Now, your lordship, they kept it pending, then we came again before this honorable court during the pendency, they forwarded the claim petitions, your lordship, to the
District Judge.
Kala, your lordship. But the difficulty is, your lordship, that has not been registered, your lordship. The requirement of section 65 of the act has not been followed by the principal secretary, your lordship. That's why, your lordship, they have not even, the honorable court has not even been registering these cases, your lordship, land acquisition cases, your lordship. That is why we are before this honorable.
Yes, Mr. Musari. These are all the actual dispute has not even arisen.
Lord,
This is only the procedural part. We should facilitate the procedures to be completed so that their merits dispute or claims can be adjudicated on merits.
Lordship.
Heard. 3. As Botakur learned counsel for the petitioners who are aggrieved by non-completion of the required formalities to facilitate a reference
Lordship.
made by the petitioners under section 64 of the So-and-so Act 2013. Full stop. Let notice be issued, returnable on 25th of May,
Lordship.
2026. 3 BC Musar and Standing Council, BTC, accept notice on behalf of all the respondents.
All the respondents.
What about 3, Mr. Musari? Secretary, competent. You can take.
Secretarial.
Okay, all this. Let extra copies be served upon him. Okay.
Deeply
You come
obliged.
up with instruction.
Lord.
These matters perhaps we should dispose of at the
Lordship.
admission stage.
Deeply obliged.
11.
May I please, your lordship? Lordship, in this matter, the other petitioners are landless Indian citizens
belonging to economic weaker sections and marginalized sections of the society. They are permanently residing in Bongora, Islampur, Pachaniapara areas for the past 25 years along with their families. Lordship, on 14th March 2026 and 15 March 2026, the respondent authorities initiated a large-scale eviction drive in the such areas, Lordship. It was carried out without following the due procedure of law by the respondent authorities. At presently, they are staying in Maxif Hills, Lordship, near Islampur area, Bongara.
What is your prayer now, madam? What do you seek?
Similar order was being passed by this honorable court in WPC 888 of 2026. The order is annexed here in Annexer 8, page number, Lordship may refer to page number 123, 129, Lordship.
At this stage, we'll issue notice, we'll examine your interim prayer on receipt of notice.
Lordship,
Yes, Mr. Tarudar, where are they now after the eviction? Take instruction, we'll issue a short notice at this stage.
Lordship, some interim protection may be provided, Lordship.
Only after the instructions.
Ongoing rainy season, for this ongoing rainy season, they are facing difficulties, Lordship.
No, then we'll have a short date, let him have the instruction. 2 weeks, okay. What is your name, madam?
F. Farid,
F,
Farhin Farid, Lordship.
you're not there on record.
Lordship, I'm there.
Huh?
Farhin Farid.
F Farid, then I don't know. As heard Miss F Farid Learned Counsel for the petitioners. Put the grievance of the petitioners is connected to the eviction, which according to them have been done without following the due process of law. They have also alleged that the present condition is deplorable, where no assistance is granted by the state. Let notice be issued, returnable on. We'll give a short date, Mr. Today is 24th, on 15th of May. 15th of May. Three. Chief Secretary, you for one, Mr. Mehdi for Chief Secretary.
1, 4, 5, 6, 7, and 11.
Three PK Metal and Council assisting. Three BJ Taludar, addition senior advocate, except for one.
1, 4, 5, 7, 11.
Behisa,
1, 4, 5, 6, 7.
who is for two? For two, Union of India. What is your name? You are a CGC. Who's your senior? On behalf of number two, revenue, Pachaji for three. Then rest, who else? Health, health, 8 and 9, health, Chaliha. Then elementary education, B, Deka 10. Food and civil supply, you have already taken. Water resource, who's there normally? P Chakraborty is there. Or N Upadhyay. Who is for irrigation, who is for water resource? Huh? P Chakraborty. P Chakraborty for 12, 13. You for 14. M Kolita, Standing Council PHE for 14. Who is for 15? Flood and River Irrigation Management Agency of Assam. I think you can take Mr. Huh? 15, you have to take steps by speed post. Okay. Rest you serve extra copies. You have noted the names of the council who are appearing. Serve extra copies. Again, 15 come up with instructions. They have some interim press. Okay. Huh? কি হয়েছে? কোন? CGC is for whom? Respond number? Now on behalf of whom did you appear? B? B Deka. Okay. Vibhushan Deka. On behalf of respond number 2, Ministry of Home Affairs. Okay. Next.
Obliged lordship.
I can. May please, lordship.
Yes.
This is my lord, petition claim for ex-gratia, my lord. Minor daughter of the petitioner, my lord, died due to drowning in the, my lord, in a pond situated in a, my lord, wetland, my lord. During the rainy season, my lord. The petitioner filed a representation before the deputy commissioner, my lord. That was not considered.
Yes, we issue notice.
My lord.
When was the death?
25/5/25, my lord.
Heard Sri H.R. Ahmed, learned counsel for the petitioner who has approached this court with a claim for ex-gratia pertaining to, connected to deaths of her minor daughter on 25/5/2025 by drowning. Full stop. The petitioner has relied upon the guidelines of the government as published in the notifications dated in the latest notification dated 2/5/2020 to 2015 para. That notice be issued. Returnable on 25th of May 2026. Number 1 is whom? Revenue, A. Bhattacharjee, Revenue 1. Then P.K. Medhi assisting to answer for 2, 3, 4, and 5 extra copies. Serve extra copies.
Item 13 of the same incident. Petitioner is the father of the deceased.
13 and 14. 13, only 13. 13 to her to his way of purpose.
Yes.
Or at her and summary.
Same incident.
Respondent number 1 is Mr. Bhattacharjee? Yes. Same respondent, respondent is the same.
Same
Okay.
incident, same.
Okay.
Obliged.
Item 14.
May
Yes.
I please, your lordship? My lords, in this matter, I have been deprived of my property since 1962, my lords.
Deprived of the property in what sense?
My lords, I have a property in my name, my lords. I have got this property by way of succession. My lords, may kindly have page 32, my lords.
But how do you explain the delay?
My lords, because I've just recently discovered the papers, my lords. That's why.
Will it be a reason enough, good enough?
My lords,
From 1962, your property is not with you.
my lord, there is a
You come to this court in the year 2026.
My lords, there is a continuous cause of action, and my lords, in the Vidya Devi judgment, the court has said that the High Court is duty bound when there is a deprivation of property, my lords, in breach of Article 300A. My lords, my lord, I'll produce Vidya Devi judgment.
1962. How do you explain?
My lords, we have recently been discovered this document, my lords. We have just got aware of this fact.
Where are your statements? Where are
My
your statements?
In my pleading, my lord, I'll just show. Pleading, you know what? My lords, in para 4, my lords.
Paragraph 4. Yes, please read.
My lords, I'll just read it out for your convenience. That the petitioner has recently discovered the document particular land in dispute. Subsequently, to ascertain the status of the said land, the petitioner filed an application under the RTI bearing RTI number so and so on 27th of June 2024. In response to which, the Circle Office of Rangya, by its reply dated 5 August 2024, explicitly stated that the railway authority is in possession of the said land without any acquisition order. My lord, there is no acquisition order, and my lord, there are Supreme Court judgment which says that acquisition order has to be given. Otherwise, the court cannot.
Don't go to Supreme Court order, mister. State the facts first.
Yes, my lord.
We know about Supreme Court orders.
My lord.
This is not how you place your case. What are the facts?
My lord,
Why the delay?
My lord.
Are you an illiterate person? Vidya Devi pertains to an illiterate lady. Are you an illiterate person?
My lord.
Are you a minor?
My
You are
lord.
56 years. What is your explanation? You start with a Supreme Court case.
My lord, we have recently discovered this.
Aren't we required to know the facts of the case? Or we apply the laws just like that?
My lord. My lord, may kindly have in the Vidya Devi judgment, there was a.
We have seen Vidya Devi. We know Vidya Devi.
My lord, there was a.
Vidya
delay
Devi
of
is a
5
illiterate
decades.
lady.
My lord,
Are you illiterate? How do you equate Vidya Devi with this case? All cases will depend on the facts and circumstances. You cannot just put up case like this.
very right.
You don't explain the delay of 1962. Where does the Limitation Act goes? For a toss. You are saying continuous cause of action. What is the continuous cause of action? Can you explain what is the continuous cause of action?
Yes, my lord.
Don't use expressions like this. Continuous cause of action. What is the continuous cause of action? Let us understand
My lord,
from you.
Because I have the right to change the property, and my lord.
What is the continuous cause of action? What is the meaning of continuous cause of action?
that the cause of action has been going on since the deprivation.
So there will be no limitation.
My lord, my lord.
Where does the Limitation Act 1963 goes?
My lord.
For a toss. It's not that easy.
My lord, we have
Try to frame your case.
Facts, my lord.
What these pleadings are wholly inadequate. Why aren't you aware? Where are you staying? Suddenly you say that you have discovered the document. Why?
My lord.
You are not staying there. There are no background facts. It may be a case that you are staying somewhere else. You are not aware. You have not stated anything. You are not a minor. You are 56-year-old.
My lord, all I'll pray for is, my lord, there is a continuous cause of action, my lord. My lord, may kindly consider this, my lord.
We are not convinced at all. You come to the writ court. This is a writ court of equity. If you are barred by law in a civil court, the bar will be much more in force in a court of equity. That is the law.
My lord, on this regard, my lord.
You are an equitable jurisdiction.
My lord, the title is not in dispute, my lord. My lord, we have just recently got knowledge of this information.
So can you come to the court at any time you feel? From 1962 to 2026. How many years?
More than 5-6 decades, my lord.
So where does the limitation goes? Writ court will ignore everything. Can you approach a civil court with this?
No, my lord.
If you cannot approach civil court, you are out of the writ court also. That is the law.
My lord, I'll just throw the area. No. My lord, can I refer to one more case, my lord? My lord, Sumitra. My lord, I'll just serve the judgment, my lord. Let me just make my argument. My lord, in para 29 to 32, it is said that this is clearly a case which is not only depicts the breach of petitioner constitutional right guaranteed under Article 300A, but also a case of continuing wrong, as the illegality of an exploration of a petitioner land is compounded on day-to-day basis. By non-payment of compensation, the petitioner could not be deprived of the right to property unless the procedure in laws as mandated under the statute. Tukaram.
You read the paragraph 4 and 5. There is an acquisition proceeding. It was a subject matter of challenge continuously from there. You come prepared with this aspect of delay on Wednesday next.
Grateful fellow.
What is your name?
D. Radi.
Heard Sri G. Rathi, learned counsel for the petitioner. Full stop. The petition has been filed for a cause of action which had arisen in the year 1962. Para? Not para. In paragraph 4 of the petition, the petitioner, a statement has been made that the petitioner has recently discovered certain documents. Full stop. The petitioner appears to be an educated person who is aged 56 years, and the causes shown may not be deemed to be adequate for invoking the equitable jurisdiction of this court under Article 226 of the Constitution of India. Sarah, at this stage, the learned counsel prays for and is granted time till Wednesday to take further instructions and make submissions.
Grateful, Your Honor.
Yes,
Lordship, this is a matter relating to cancellation of GST registration. Lordship, this is in this case, Lordship, the mandatory 30 days notice was not given. Lordship, this is relating to Rule 21. Lordship has already held that under Rule 21, the mandatory 30 days notice has to be given. In this case, Lordship, 30 days notice was not
what do you
given.
say, Mr. Barlow?
Lordship,
We'll try to dispose of at the admission stage.
this
We'll
can be
give a short date if that is the only case.
That's the only.
Then we'd like to pass final orders, okay?
Okay, can I
Heard.
pass on the?
Now we'll give a short date. Heard Miss Anne Haveli, a learned counsel for the petitioner, who is aggrieved by an order dated 9/6/2025 passed by the Respondent 3, whereby the GST registration of the petitioner has been cancelled. Full stop. Amongst other, it is contended that the respondent authorities did not provide the mandatory 30 days notice. Notice before such cancellation. Let notice be issued. Returnable on, how soon can you get back, Mr. Barua? Today is on 15th. You get enough time, 15th. 15th of May. Sri H. Barua, learned counsel, accepts notice on behalf of all the respondents. All the respondents, extra copies. Full stop. Depending on the instructions that may be received, this court would pass appropriate orders on an date.
May I keep this on record, Lordship?
What is it?
Similar order, Lordship, as.
Next date you place before this court.
16.
May I present?
Yes, Mr.
I'm
Bhattacharya.
making a challenge to the award passed by insurance ombudsman. My lord, the insurance.
Rejected. Rejected.
No, they have
Who are you?
passed award. I'm
Oh, you are the insurance company.
insurance company. Well, on the, we repudiated the claim on the ground that the patient has a pre-existing disease, which she did not or he did not disclose at the time of taking the policy.
When was the policy taken?
2020.
20.
Yes,
Premium was paid every year.
yes,
When was the repudiation done?
in 2025.
25.
Yes.
5 years you had taken the premium.
Yes,
And before taking the premium, you did due diligence.
no, it is on the basis of her statement, we proceeded. It is
While
absolutely,
taking the premium, you're very happy.
no, on
While
the basis,
making a payment, you raise all sort of objections.
no, this is part of the terms and condition. My lord, I can
What
prove.
is
My
your challenge?
lord, lordship may kindly see page 40.
Mr. Bhattacharya, you're inviting cost while dismissing. we know how you act, the insurance company. While taking the premium, there is absolutely no objection. But while there is a claim made, you come with hundreds of objections.
No,
Why do you take the premium?
my lord, we-
Why no due diligence before taking premium? Why don't you insist upon a medical before taking premium? Did you take a medical before the premium, last premium?
No,
Then
my
why
lord,
do you raise this issue?
lordship may kindly
This is a claim for what?
medical,
Medical,
yes, my lord.
medical expenses.
Yes, my lord.
How much was the claim?
Claim of, my lord. 2,04,000.
How much was the premium?
Nine, premium, 42,000.
Per year?
50,000 for the entire family.
50,000.
Yes.
From 50,000 from 2020 to 2025, you are collecting the premium.
No, it's a violation of the policy terms and condition, my lord. I can show, my lord.
The violation started from which year?
From
If
2020.
you're emphasizing on utmost due diligence, utmost due diligence, what has happened from 20 to 2025?
That disease was not came to our knowledge, my lord. She meant
Sorry. Not a case. We are not going to encourage this kind of litigations. Let us see if there is any illegality glaring on the part of the ombudsman.
Yes,
What is it?
page 40.
40.
Yes. This is part of our terms and conditions of the policy.
No. Let us see the ombudsman's order.
Ombudsman's order. Page 78 onwards. 79.
Yes. What is the illegality here? Yes, please read the reason of repudiation. The insured patient has a history of osteoporosis, knee, high, TPL. What is this? Osteotomy done on 2013.
30.
Which is prior to the inception of the health policy. 2013 it was done.
Yes.
And the health policy was taken in 2020.
20.
Okay. Hence, the said diagnosis is a pre-existing disease. The present hospitalization and treatment or insurance is for pre-existing disease. Okay. Date of receipt of total reputation claim
Lordship, may
0.
kindly go through that portion of the terms and condition. I'll explain, my lord. Why it is material, my lord.
No, we'll say first you read the order.
Yes.
But we should to so complain. Policy was
Treatment of
incepted
misery,
on
yes,
28/9/2020. 28/9/2020 policy. Thereafter, ensued. Please read the
Observation.
brief facts of the case.
Brief for
Family Health
Optima insurance plan bearing number so and so was issued to the complainant insured by the respondent insurer. The policy inception was on 28/9/2020. Insured Mrs. Binu Datta Borua, the wife of the complainant, was admitted in Life Care Multi-Specialty Hospital, Patna on 12/5/2025 for treatment of pain in the knee. The patient was diagnosed as grade 3 osteoarthritis, right knee plus diabetes mellitus plus hypertension and hypothyroidism and treated there. After getting released from the hospital, the complainant had submitted a reimbursement claim of rupees 2,38,149. The RI, respondent insurer, had rejected the claim of payment considering that the insured patient had a history of osteoarthritis, knee, high, tibial osteotomy done on 2013. Exactly the same treatment, my lord, which is prior to the inception of the health policy. Hence, the said diagnosis is a pre-existing disease. The present hospitalization and treatment of the insured
is for that pre-existing disease. The complainant disagreed with the decision taken by DRI regarding delaying of his claim for payment and hence the complaint. This is.
Yes.
Then contention of the complainant. This is
Yes.
the complaint. Contention of the respondent. The
Health policy was procured.
health policy was procured on 28/9/2020, including the insured patient. She was admitted in the hospital on 12/5/2025 for treatment of knee pain. He had submitted all necessary papers to the respondent insurer for settlement of the claim in time. The claim was also registered under claim intimation number so and so. The RI informs that they are unable to settle the claim, hence it is approach this forum for redressal.
Yes.
Now, contention of the respondent. The insured patient, Mrs. Binu Dotto Borua, aged so-and-so female, was admitted on so-and-so at Life Care Super Specialty Hospital, Patna, for the diagnosis of grade 3 OA knee, valgus deformity, DM2, HTN, and hypothyroidism. Operation was done on 14/5 and was discharged on 29/5. The insured submitted claim during the 5th year of the policy period. The insured submitted claim to the amount of so-and-so. As per discharge summary, it is noted that the insured had undergone a high tibial osteotomy in 2013 on the right knee, which is a surgical procedure typically performed for the alignment of the osteoarthritis.
Management, not alignment, management.
Management of osteoarthritis of the knee. On scrutiny of the medical records, it is noted from AIMS Gauhati OPD sheet dated 4/11/2024 that the insured had undergone a surgical intervention on the right knee in the year 2013. The insured patient has the above diagnosed disease prior to the inception of the first medical insurance policy. The present admission and treatment of the insured patient is for a pre-existing condition which is not payable for Section 3 exclusions, pre-existing disease code exclusion 1.
Yes.
The company shall not be liable to make any payments under this policy in respect of any expenses whatsoever incurred by the insured person in connection with her current ailment. Observation.
Okay.
The complaint was taken for hearing on so-and-so. The complainant was present physically before the forum. She so-and-so, the representative of the insurance company, physically attended. The respondent insurance submitted that claim has been refused on 5/7/2025 since the insured patient had a history of osteoarthritis knee-high tibial post osteotomy done in 2013, which is prior to the inception of the medical policy. Hence, the above diagnosis is a pre-existing disease, and as per code exclusion 1 of the policy issued to the insured, the company is liable to make payment for any pre-existing disease only after expiry of the 40th month from 1/7/2025. That is the date on which we came to know. The rejection letter further states that non-disclosure of the disease was found while processing the claim, and as such the claim is not admissible. The respondent insurer further submitted that as per the outpatient slip of AIMS Gauhati is seen that patient had a history of surgical intervention of right knee in 2013, which was not disclosed by the complainant. He had further stated that the slip issued by Dr. Asim Ahmed of Life Care Institute Care Multi-Speciality Hospital, Patna, shows that the patient had the grade 3 osteoarthritis right knee, that is valgus deformity, along with DM, HTN, and hyperthyroidism. In view of the same, it is clear that the policy does not cover any pre-existing disease for 48 months from the date of inception, and that non-disclosure of surgical intervention in 2013 amounts to non-disclosure of PED, pre-existing disease. Hence, the claim is not payable. The forum observes from the medical documents presented by the respondent insurer that during admission from 12th of May to 29th of May 2025 in Life Care Multi-Specialty Hospital, Patna, the doctor had mentioned about the inclination history, stating that the patient underwent high tibial osteotomy of a right knee in 2013 and was diagnosed with grade 3 osteoarthritis of right knee, which was valgus deformity, along with diabetes, hypertension, and hyperthyroidism. As far as the other document, that is the OPD slip of AIMS Gauhati is concerned, it provides the patient had a history of surgical intervention of right knee in 2013. The forum asks the complainant to clarify the points raised by the respondent insurer. The complainant submitted that his wife had a problem in the right knee, which was known as HTO, high tibial osteotomy, in which some surgical procedure was carried out in 2013, and thereafter she never had any problem in knee. He further stated that as the knee problem was fully resolved after the surgical procedure in 2013, he did not disclose the same while filling the proposal for insurance of the policy. The complainant continued to state that he and his wife both are suffering from diabetes, and this fact was clearly mentioned in the proposal form along with the medicines that were taken by them to manage the diabetes problem. There was never any intention to hide any fact while making the insurance policy. The complainant contended that neither there was any PED that was hidden, nor there was any intention to hide any fact. The policy has been in force since September to the 28th of September 2020. The forum notes from the IRDA regulations 2024 dated 22/3/24 that pre-existing disease means any condition, ailment, injury or disease that is or are diagnosed by a physician not more than 36 months prior to the date of commencement of the policy issued by the insurer. In the present case, the surgical intervention in the right knee was carried out in 2013, which was about 12 years prior to the present case, for which the claim has been preferred. Therefore, the respondent insurer are wrong when they call the surgical intervention of 12 years earlier as pre-existing disease. Therefore, the rejection of the claim on the ground of that PED was not recovered for a period
Not
of
covered.
was
No.
not covered for a period of 48 months or 36 months, as is the case now, is not justified and totally incorrect. Respondent insurer argued that claim has not been denied on PED ground, but they have also mentioned the rejection letter that earlier condition was not disclosed to them. On this point, complainant and clarified that since his wife did not have any knee problem at the time of inception of the policy, there was no way that they could have disclosed about an issue which occurred 12 years ago. The respondent insurer further argued that the medical condition was a result of progressive development of osteoarthritis, and it is from HTO disease that was managed through surgical intervention in 2013. The forum notes that high tibial osteotomy is a surgery that realigns the knee joint to correct the knee problem. The deformity can arise in the younger individuals between age of 45 to 65, either due to osteoarthritis or due to any injury or other reasons too. That earlier problem in 2013 was result of osteoarthritis is not an established fact. Therefore, the respondent insurer is not authorized to link a procedure conducted about 12 years ago in the present issue of valgus deformity. The forum further desired that the complainant should submit a self-declaration regarding medical condition of his wife during the last few years, particularly to bring his version on record. The complainant has submitted a written declaration that stating that during the last 4 and 5 years, the insured patient did not have any complication of knee and enjoyed her day-to-day life comfortably. In view of the aforesaid and in absence of any conclusive evidence to suggest that the 2013 ailment was a result of osteoarthritis, the forum is not inclined to accept the submissions made by the respondent insurer. The claim has been denied by the respondent on the ground of mainly pre-existing disease. Whereas, as per IRDA regulations 2024, there was not a case of PED since no problem has occurred to the patient during the last 48 months prior to the present ailment. As such, the claim is admissible. This is the finding, Manu. May I read further or should I take the page 40?
What is it? What do you want to show?
Page 40. 40. This is terms and conditions of the policy. This is the exclusion part. Page 40.
Yes.
Lordship has but the exclusion
40.
Standard exclusion. Number 1, pre-existing disease.
Yes.
A. Clause A. May I read, my lord? Expenses related to the treatment of pre-existing disease and its direct complications shall be excluded until the expiry of 48 months of continuous coverage after the date of inception of the policy with the insurer.
So this is 4 years.
Yes.
So this is applicable.
No, I read further. The last one, my lord.
Hmm.
Coverage under the policy after the expiry of 48 months for any pre-existing disease is subject to same being declared at the time of application and accepted by the insurer. So had it been disclosed, we would not have given our any expenses for 48 months, but beyond 48 months, we would have taken that risk. But we have to be informed.
2013.
Yes, it has to be informed. Then we would have got the opportunity.
What about the findings of the learned ombudsman
Ombudsman.
on this matter, on this point? At page 81,
81,
second paragraph and third paragraph.
third paragraph. The forum notes that high tibial osteotomy is a surgery that realigns the knee joint to correct the knee problem. The deformity can arise in the younger individuals between 45 to 65, either due to osteoarthritis or due to any injury or other reasons too. We do not know where from this is being inserted. This is absolutely not borne up out of any record.
Let us see your policy. Star Health. You advertise a lot that you cover everything. Let us see what you covered.
Policy page 26.
33.
Terms and insurance.
Hmm.
Terms and conditions.
Yes.
Preamble, the proposal declaration and other documents given by the proposer shall be the
Accident,
basis of
any
this
one
contract.
illness.
The first line itself. Man.
Hmm.
The proposal, declaration and other documents given by the proposer shall be the basis of this contract and is deemed to be incorporated therein.
Correct. Standard definition, accident, any one illness. What do you cover? You say of cashless facility.
Yes.
What do you cover? Illness. At page 33. Illness means a sickness or a disease or a pathological condition leading. Mr. Bhattaji, we are of the opinion that the order has taken into consideration of the relevant factors. The pre-existing, if you say it's a PED, that is of the year 2013.
But it has to be informed at the time of.
Would
And
it,
in
would,
fact,
would,
by-
would it be a relevant consideration? Is it a disease?
Yes, for the same problem, he has been diagnosed in 2025.
13, some
Of the right knee operation was
some
done.
treatment was done in 2013. 2020, the policy was taken. The
Yes.
claim has been made in 2025 and you reject.
Yes.
At some cases, we have to put our foot down. So this is one of those cases. We understand that insurance policy is a policy, a contract of utmost good faith.
Yes.
But we don't think that this is a case where utmost good faith was not discharged by the insured. We'll dismiss your case.
Right.
We should draw the bill.
Obliged.
Item 17.
Petitioner. Before my learned friend start, in respect of same cause of action, the petitioner has filed another petition, which is pending, WBC 94/26.
Same cause of action.
Same.
Why
What is
is it-
only,
No, your lordship, kindly peruse,
here only the appeal filed
page
by the
49.
Government file is under consideration. What I say, to avoid or to rule out any conflicting order, lordship may take up on Tuesday or Wednesday, both the cases.
Both the cases. This is
Same
also my.
petition, Same cause of action, same society, everything same. Only
But
an
during
additional
pen-
order is challenged, but
During
That-
pendency, your lordship, this was.
He
the
must
case.
have disclosed this here.
now this is his disclosed, my
Dis-
lord. What I'm trying to say, my lord, this is a consequential order, my lord, which was not necessary at all. He has filed it, I have nothing to say. But what I'm trying,
Okay, well, Tuesday.
Tuesday, my lord.
When is that matter fixed? The other matter?
Not fixed date, only notice has been issued.
Notice was issued.
Issued, yes.
That he has annexed the,
Order also, yes.
he has annexed the order.
Okay, then we can issue notice and merge with that case.
Yes, only if your lordship can issue. notice.
Heard Sri K. Mira Learned Counsel for the petitioner who has put to challenge orders dated 29/10/2025, 12/12/2025 and 31/3/2026 passed by the respondent authorities under the Assam Cooperative Societies Act 2007. Full stop. By the said orders, the request of the petitioner to hold the annual general meeting within bracket AGM of the Manipur MO, NIPUR SS Limited for the year 2025-26 has been rejected. Full stop. It has been contended that such rejection has been done arbitrarily. Let notice be issued. Returnable on today. On 22nd of May 2026, 3 Talukdar
Except 6 months.
for 1, 2, 3, 4, 5 and 7 extra copies and 6 by People's Petition. Full stop. 3 Talukdar has however informed that the petitioner has earlier filed WPC
94/26.
94 of 2026, wherein a part of cause of action would be common. Full stop. In view of the above, list along with sense.
Obliged.
You serve extra copies.
Yes, obliged.
May it please your lordship.
Yes.
The petitioner is a legally married wife of a deceased who was expired on 2/5/2023. And out of his marriage, their marriage,
2/5/2022, your husband passed away.
yes.
Then
And one of the respondent 4, with the help of Gaon Panchayat certificate, issued a death certificate on her name, claiming she is the
wife.
wife.
R4 is claiming to the wife of the deceased.
Deceased.
Okay, what have you annexed? Your marriage was conducted by in a social manner, or was there any
The agreement, copy of deed of marriage agreement dated 15/11/1989 is annexed as an
Marriage agreement? What
Yes.
is this document?
The deed of marriage. Page number. Page number 13.
1/3.
Yes.
But what will this have? This will not have any legal sanctity. What is a marriage agreement? It's not a legal document. Either you have to have the marriage certificate by the appropriate authority, the sub-registrar, or a social marriage. Was there any social marriage?
There was a social marriage.
Have you pleaded? Have you said anywhere in the petition that there was a social marriage? Madam Bora?
No mention anywhere, but it's just okay.
Oh, no, no. You have a son.
Yes. No.
You have not even stated there was a social marriage. You only depended on the deed of marriage agreement. That is not a legal document. Now, what is your problem?
The problem.
R4 is stating that claiming to be the wife of the deceased.
Yes.
And thereafter,
We have.
is there any claim?
Yes, we have made a presentation also, but till date, there was no response from the.
No, by claiming to be the wife of the deceased,
Yes.
is there any further claim by the respondent 4
Yes, madam.
regarding any benefits?
Yes, there is.
What is your husband was a government servant? What was your husband doing? You have not stated, was he a government servant, was he on business? What was the source of income? What is an actual 5?
There's a matrimonial suit ongoing.
Hmm?
As the husband died, the divorce could not be taken.
But what do you want in this petition?
To rectify the name of the death certificate in the death certificate of the petitioner.
What is your name?
M. Islam.
Third 3M Islam Learned Council for the petitioner. Footstep. As per the facts projected, the petitioner is the legally married wife of one Loken
Yes.
Chandra Sekya, who had passed away on 2/5/2023. Footstep. It has, however, been disclosed that the marriage was solemnized on 15/11/1989 by executing a deed of marriage, and a son was also born to the parties on 2/2/1992. However, the respondent number 4 has obtained a death certificate by claiming herself to be the wife of the deceased. Para? Let notice be issued. We issue notice at this stage, Madam Bora. That notice be issued returnable on the 25th of May, 2026. Madam Bora for 1, Health. 1, 2, and 3 health. Family. Who is 5? Gaon Pradhan. 1, 2, and 3 extra copies, 4 and 5 by speed post AD. Kept it into working this.
Obliged.
Okay, you take steps, but we don't think you have any case. Is there any issue with the other wife? Other lady?
I'll take the briefing. I haven't details.
Because see, on record, you have stated that there was a petition for grant of divorce on mutual consent. It's a different matter that the husband passed away before final orders could have been passed.
Yes.
So that has that proceeding will not make any difference, but still then. Okay. Next time, next date. Next.
Item 19.
19. Yes, madam.
Yes, please, your lordship. Lordship, in this case, lordship, we are challenging the so-called notice issued to me.
Why don't
Demand
you
was-
show cause?
Lordship, yes, your lordship. This so-called notice, lordship, why we have challenged, there are two grounds for challenging the so-called notice.
13.3 is the so-called notice.
Lordship, the so-called notice is 13/3/2026.
Yes.
So lordship, that is at page 99.
Yes.
If challenging the so-called notice on two grounds, my first ground is that there is a bunching of so-called notice, lordship. There are 3 assessment years which are bunched together. That is 2021, 2020, 21, 21, 22, and 22, 23. 3 assessment years have been bunched together.
Okay.
Lordship,
Is there any bar?
Yes, your lordship, there is a bar. In lordship, so far as GST is concerned,
This so-called notices are issued under 74.
lordship, that is also one of the considerations. This is my second issue, that this is, even though the so-called notice is issued under section 74, there is no allegation of fraud, misstatement or suppression of facts.
You want to contend that 74 would not be applicable.
Yes, your lordship. Because they have not even told that the lordship will, I'll put both the condition, lordship. First, I will try to convince your lordship on 74.
First, show us the bar that the
Lordship, I will,
consolidated show-cause cannot be issued
Lordship.
for 2020 to 23.
lordship, even though there is an interim order which has been passed by this honorable court, I'll produce a judgment of the Bombay High Court in this respect, a least recent order, which will clarify everything, lordship. The entire my
Or
arguments
interim order
are,
passed in which proceedings?
lordship, against the so-called notice, lordship.
In this proceeding?
Not this process, some other cases.
Other similar.
Some other cases. Lordship, this is a lordship case before the Bombay High Court. Lordship will kindly see at page 13, interim page 13. This is an order
13.
of 13.
1-3.
Hmm.
1-3, madam.
1-3. Yes, your lordship. 1-3.
Yes, what is
I'd
that?
like to show what is the lordship. This is an order of 17th April 26. In this batch of petitions, the primary issue raised by the petitioners relates to issuance of a single consolidated show cause notice under section so-and-so of the Central GST Act, bunching multiple financial years. It's the petitioner contention that the same is against the mandate of 7310 and 7410 of the CGST Act.
Yes,
It has-
Mr. Dr. Gogoi, what do you say?
Lordship, the same judgment of this petition, your lordship, if lordship permit me to the last page, your lordship, page 123.
Of the petition?
Yes.
Yes, what is there?
Paragraph 18, the judgment says of the Ambika. The Delhi High Court thus held in a case involving allegations of fraudulent availment of ITC spanning several years, a consolidated notice may be permissible, as the pattern of fraud may not be capable of being established in isolation for each financial year. Thus, in milder of good art developers supra, the court distinguished the judgment of the Delhi High Court in Ambika Traders. On the ground that in the facts of the case, there existed a common and individual cause forming the whole soul of basis of the proceedings, and it was not possible to establish the same without clubbing the notices pertaining to the different financial years. The Delhi High Court permitted the issuance of consolidated show cause notice covering multiple financial years. And accordingly, you know, see the act, another judgment by Mathur, polymers also. In the paragraph number, if lots of permit, I can.
Consolidated show cause is permitted. It's not per se illegal.
No.
It will depend on the facts of the
Facts.
cases.
Facts of the case.
73, 3 and 74.
Lordship, as per the judgment of Delhi High Court.
Madam, if there is no illegality per se in issuing a consolidated,
No illegality. But lordship,
then you have to make out a case on facts.
no lordship, may kindly, I would like to show that this is a burning issue.
That's
Although
why we are asking this question,
Yes.
because you have approached this court at the very nascent stage. Without even furnishing your reply,
No,
you
your
want the proceedings to be interfered by this court, not
Lordship.
only stayed, interfered by this court.
lordship, because lordship, the so-called notice which has been issued for consolidated assessment, in all the cases, lordship, the case has been because on the basis of so-called notice only the same has been challenged, because the so-called notice is illegal. There's no jurisdiction. Lordship, may kindly, if I may be permitted to read this judgment. Lordship, this judgment covers all the judgments of the entire India. In the entire country, lordship, various high courts have, lordship. That is why I was.
But are you disputing what Dr. Gogoi has just read, that a view has been taken by the Delhi High Court, which says that it is not per se illegal, it will depend on the facts and circumstances.
But
So there are diverse views.
diverse, lordship.
So
see page
that may not be a case for grant of an interim order.
Lordship, 14 high courts in the country have held in my favor that no, it cannot be there. In CGST, since there is a limitation which has been given and it is per
Is
assessment
there
year.
any ruling of the Honorable Supreme Court?
Lordship, the Supreme Court, Lordship, this is the full bench of the Bombay High Court, because the matter has been referred to the full bench, all the judgments have been referred. Lordship, may
It's a
kindly see
full
page
bench.
14.
Is it a full bench?
Lordship, it has been referred to the full bench.
Okay, yes.
Lordship, may kindly see page 14, this will clarify your
Yes.
Lordship, my case.
Hmm,
Page 14, Lordship.
hmm.
All the judgments of the entire India has been, the petitioners, Lordship, I will read from page paragraph 2.
Yes.
Petitioners have contended that a coordinate bench of this court is, in the case of Millrock, has held that there is no provision in the CGST Act to club various tax
No,
periods.
madam, examining is not a problem. We can examine.
Yes, your Lordship.
But you are definitely praying for a stay order.
Lordship, similar cases have already been stayed, Lordship, in this case. So there are 3, 4, 5 series of cases are there.
Let's see.
Lordship, I'll show one of the order is, Lordship, the.
Ms. Dr. Gogoi, have a look at this order.
I have also judgment regarding the participable
Quantum
for several,
Oh.
in one.
Judgment by which court?
Delhi High Court in Mathur Polymer.
No, the Mathur has been discussed here. In the Bombay High Court case which madam has referred, the Bombay High Court has taken all the diverse views. And so there are decisions in your favor, there are decisions in madam's favor. But there, see, this has to be stressed out. There is no law till now laid down by the Honorable Supreme Court whether consolidated show cause is permissible in law or not. Delhi says that in particular facts and circumstances it is permissible. So, but there are, madam is relying upon some judgment by our court.
Lordship, this is these are interim orders wherein the demand cum so cause notice have been interfered. I've referred to 2 cases. There are 10 to 15 cases, Lordship. There is a 2 series in different high courts are being heard, Lordship. Lordship, the challenge made in this writ petition, if your Lordship is taking Gupta hardware, the challenge made in this writ petition is to demand cum so cause notice made in consolidated form for 3 assessment years. It is strenuously contended that demand cum so cause notice in a consolidated form for 3 assessment.
Okay, we'll follow this for the time being. Just the Gupta hardware, madam is having.
I have faced this Ambika Traders, paragraph number 43.
Ambika traders have been considered, Lordship. It has been considered in this interim order. In this interim order, Ambika traders have been considered. Paragraph 3, Lordship.
Dr. Gogoi, you are only on the examining on the prima facie case. Motion stage. We are not expressing an opinion. So if the show cause is not stayed, the matter will become infructuous.
Yes.
But to stay, they have to make an prima facie case. There are 2 views. One, that consolidated show cause is permissible. There is another view, consolidated not permissible. Bombay High Court has taken into consideration all the different cases and referred the matter to a larger bench, full bench. In the meantime, this aspect has also been considered by our court, and in the interim, it's been directed that do not take coercive action. We'll follow that. I will try to sort out the matter.
Coercive and further steps, Lordship, because if Lordship say coercive, they take steps of coercive and further steps. That is my only submission. In this case,
means what is further steps?
Lordship, what happens? They call for the hearing of the case. They say that coercive action means I will not recover from you. So Lordship may kindly see coercive and further steps in this matter. That is my submission, Lordship.
Okay.
In this case also the same is there.
Heard, Miss N. Haveli, Learned Counsel, for the petitioners who have put to challenge show cause notice dated 13/3, is it 13/3? 13/3/2026 issued by the Assistant Commissioner, CGST, Nagaon, full stop. Amongst others, the primary grounds of challenge is that the show cause pertains to 3 financial years, which is not permissible in law, full stop. It is additionally contended that though the notice has been said to be issued under section 74(1) of the CGST Act 2017, the ingredients of the said section are not fulfilled, and therefore there is error of jurisdiction. The Learned Counsel has also placed before this court a recent order dated 17/4/2026 of the Honorable Bombay High Court within bracket Division Bench, wherein after noticing the diverse views on the aspect of consolidated notices, comma, the matter has been referred to the full bench. Para, let notice be issued, returnable on 25th of May 2026. Dr. Gogoi, B.N. Gogoi, learned, you appear as CGC or what? CGC. CGC accepts notice on behalf of all the respondents. Let extra copies be served upon him during the course of the day. Para. The learned counsel for the petitioner prays for an interim order and has also submitted that interim orders have been passed in similar matters, including WPC 5671 of 2025 and WPC 20 of 2026. Para. Considering the above, comma, it is directed that till the returnable date, the respondent authorities shall not take any further coercive action. Qua the show cause the impugned show cause notice dated 13/3/2026. Since this order has been passed at the motion stage, comma, the same would be reconsidered on the returnable date after receipt of appropriate instructions. Okay.
Much obliged.
You can place this on the later date and this.
And the item 20.
Yes, Mr. Chaudhary.
My lord. This is regarding a motor vehicle, my lord.
Regarding?
My vehicle was kept by respondent number 5, your lordship, really by without any authority, your lordship. But,
Vehicle was what? Hired.
my lord. Page 13, your lordships. Page annex 3, my RC. But without any authority, they are transferring my vehicle yourself. He is flying the vehicle.
You have taken a loan or what?
My lord, I have also loan. They have not paid the loan. I shall have to pay the installment, your lordship. But not even pay the installment to the me, your lordship.
Who is respondent number 5?
Respondent number 5, your lordship will Hiraram, your lordship.
It's a private dispute. It's a private dispute. Somebody is using your vehicle. How do you come to the writ court?
No, my lord, the police authority was involved in that cases.
But it's a private dispute.
With the collaboration of that, your lordship. They are.
It's your FIR.
My lord.
Where is your FIR?
FIR, your lordship, man. I have submitted several allegations, your lordship. Complaint, your lordship. Page 21, your lordship.
Page 21.
My lord.
No, this is not an FIR. Can you read? We have read this most humbly. It states that I am Sri so-and-so,
My lord.
resident of Deradasar, PS Sirun. I hereby report that I had sold my vehicle in the name of L.R. Badu Construction, which was sold at an amount of so-and-so to Hiraram for an amount of so-and-so monthly installment by neither purchase. This is something very bad. It's a private dispute. What is Bikaner?
Yes.
Bikaner, but vehicle is in the registration of Assam, your lordship.
Where is your this is a private
Your
dispute,
lordship
This is a private dispute.
Page, your lordship will find page 13, your
We're not going to entertain this.
Page 13.
Sorry.
Page 13.
You approach the appropriate civil court. Heard Sri R.M. Chaudhary, learned counsel for the petitioner. Full stop. Also heard Sri and Goswami, learned state counsel, as well as Miss M.D. Bora, learned standing counsel, transport department. Full stop. Para. As per the facts projected, comma, the petitioner had sold his vehicle to one L.R. Badu Construction, which, full stop, however, the same has been used by the respondent number 5 and the price of the vehicle has also not been paid to the petitioner. Full stop. The petitioner has also contended that he is required to pay the installment connected to the loan for the vehicle. Full stop. Para. In the opinion of this court, the dispute raised is entirely in the nature of a private dispute, which the respondent number 5 and this writ court may not be the appropriate forum for adjudication of such dispute. Full stop. This court has also noticed that the transactions where the documents all relate to Bikaner in the state of Rajasthan. Full stop. Be that as it may, at this stage, the learned counsel has clarified that the vehicle is presently in use in the district of Tinsukia. Full stop. Para.
Tinsukia.
In view of the aforesaid discussion, the writ petition is dismissed. Full stop. The petitioner will, however, be at liberty to raise the dispute in the appropriate civil court at Tinsukia.
Nice.
Item 21. Yes, what is this?
May I please, your lordship? Lordship, in this case, lordship, the order, there is a refund order which has been granted to me. Lordship will kindly see the refund order at page, lordship 114. That will explain everything.
Please, your lordship.
110.
Okay, but sometimes it has to be before the break. Second half, we may have difficulty. There is a very important meeting today. We'll sit, we may sit, but ask him to come soon. And the next matter, also Kyle.
Yes, your lordship.
21,
21, 20.
in the next matter, we are only asking for a notice. In this matter, lordship, only
Let
they
him
have,
come, let him come,
they have recovered the entire amount. Only 20 lakhs is raised.
let him come.
Yes, your lordship.
Item 48, something is.
48, what is this?
Lordship, we have challenged the decision of the tribunal regarding an election petition that we had filed that was dismissed. So at this stage, we are only asking for issuance of notice, Your Lordship.
Tribunal's order are amenable to writ jurisdiction.
Yes, Your Lordship, because there is no as such appellate.
It's a final order.
Yes, Lordship.
Yes,
I am the debater. In this case, he has challenged the petition which has been rejected, which was filed under section 5 of the limitation. And it is a settled law that our litigant as part of the High Court suitable decision, it is held that the law of litigation is not application to the election petition under the contract. There is division.
Lordship, I am.
so you're supporting his case or what?
No, because he filed the election petition.
If you're making that submission, you're supporting his case.
No,
It could not have been dismissed on grounds of limitation.
could have, the limitation act is not applicable.
Not applicable, that means it can be, or the section 5 would not be applicable.
Yes.
Okay.
But Lordship, learned counsel, I'm not aware is appearing on whose behalf because he was not party in the original election.
The election petition. But in this case,
On whose behalf?
Why haven't you made him a party?
On whose behalf? No, Lordship, only 5 parties were there. He was.
Are you a return candidate?
No,
Then how are you connected?
I have filed an application for disqualification of the return candidate. That was pending, and due to pendency of this election petition, my case has not been considered and disposed. And the
But in this adjudication process, what role will you have? He is challenged by his by the outcome of the election petition, where you are not a party.
No, yes, I was a party. I was included myself.
You were a party.
Yes.
Mr. Mishra, where is the order of the election petition, page 33? Where are the array of parties?
Lordship, as per the election petition that was filed, it will be on page 21, Your Lordship. I will try to locate.
Mr. Kayum, what is your name?
My name is Rafiqul Islam. In the election.
Rafiqul. Election petition, Rafiqul is a party or not?
In
It's
this
a, it
petition-
is filed against Asma.
Yes, my lord. In this petition, my lord, my name has been shown there. The petition, my lord, I have included in election.
Then in that case, Mr. Mishra, you have to implead him. Okay, heard. 3D A Kayum, learned counsel for the caveat who has lodged this caveat qua an order dated 23/3/2026 passed in election petition 25 of 2025. Full stop. The learned counsel has by the district judge Dhubri. The learned counsel has clarified that though when the election petition was presented, his client was not a party respondent, comma, subsequently, his client was impleaded as a party respondent. Full stop. However, his client has not been made a party in the present proceeding. Full stop. Correct? The aforesaid aspect would be considered. Correct? Caveat, this court accordingly observes that in case of passing of any interim order, comma, the caveat will be heard. Caveat stands the charge. Para. In the main you're right. Heard your A. Mishra.
Yes, your lord.
Heard 3A Mishra learned counsel for the petitioner who has put to challenge an order dated 23/3/2026 passed by the learned district judge, Dhubri, in election petition 25 of 2025, whereby the petition has been rejected. Full stop. Let notice be issued. 3. Mr. Datta. As Dr. Senegal 1 and 4. State Election Commission, Pastor 2. 3. What about Election Commissioner, Election Officer? 5. 5 you can take. 6 by speed post to TD, full stop. The learned counsel is also directed to file appropriate for implement of the present caveat who was a party in the election petition. Full stop. Returnable date, December. We give a returnable date. Returnable on 25th of May.
Obliged.
What is this? Aslima Khatun, who had forwarded this?
I have,
For what purpose?
because the judgment. Item 24.
May it please your lordship. Lordship, in this case, we need to take some instructions regarding the matter.
24.
24, lordship.
But for last many occasions, they are taking adjournment.
We are unable to contact the
and they
client,
are
lordship.
enjoying this.
22 matter.
Lordship.
22 matter. Why should we grant time?
Interim order, my lord.
What is the matter about, Mr. Haloi?
Matter is that, Lord, he was occupying my land. It is admittedly government land, and he made a construction. And at the same time, he applied for allotment of that land. And it was approved by the sub-divisional land advisory committee. And then I filed a complaint. On the basis of the complaint, inquiry was made, and ADC passed the order that
You have filed your returns.
my lord, I have filed.
You are R3 or R7?
Yes,
You are R3 or 7?
R7.
Who's 3?
Subsequently, it
Who is
was.
R3, Mr. Bodloy?
Lordship, Deputy Commissioner, lordship.
Deputy Commissioner also filed affidavit.
No, lordship.
Yes. Has filed affidavit. R3 has filed affidavit.
Yes,
On
lord.
15/9/20.
R3 has filed affidavit.
Lordship, this was filed on
He has
behalf.
filed affidavit on
R3 and
Oh,
R7.
ADC, lordship,
Filed
yes,
affidavit.
lordship.
ADC.
ADC filed.
ADC passed the order that already he was allotted with a government plot of land, and this is the second application. That is
Okay, we have
the
this on Wednesday next.
Lordship,
Wednesday. No further adjournment.
lordship.
Wednesday.
Wednesday next.
Lordship, can it be on Thursday, lordship?
Thursday.
Thursday by
Mr. Haloi?
Wednesday by one, Wednesday.
Heard Sri P. Borderline Learned Counsel for the petitioner. Also heard Sri, who's there? Revenue? Revenue. Bhattacharjee is there. Who's for state? State government also heard Sri, and Goswami, Learned State Council, as well as Sri, no, State Council, comma, Sri A. Bhattacharjee, Learned Standing Council Revenue, as well as Sri and I came Haloi, Learned Legal Aid Council for the respondent number 7. While Sri Bodolai has prayed for some time, prayed for an adjournment, comma, Sri Haloi, the Learned Legal Aid Council has submitted that on many earlier occasions, adjournments were taken by the petitioner. What's the para? Considering the above, and in the interest of justice, final adjournment is granted, directing listing of this matter for admission hearing.
Lordship, on 6th, Lordship. On 6th of May, Lordship, Wednesday, Lordship.
6th of May, is it okay?
Lordship.
On 6th of May.
There is an interim order, Lordship.
Interim order passed till to continue till the next date of listing.
Oblige, Lordship.
Item 25 to 28. My lord, these all pertains to water resource department, non-payment of contractual dues. In fact, my lord, there is a common order passed by the coordinate bench of this court, my lord, because there was a batch of writ petitions. Somehow these 4 petitions were also tacked up with the same batch, my lord, but these were not tacked up because of some technical difficulties, maybe no reply or something of that sort. My lord, let it be.
Actually, what happened is he made the centrally sponsored field. That is the difficulty, Lordship.
No, what Mr. Biswas is submitting that these are covered by earlier decision. Is it covered? You can examine that aspect. If it is covered, please furnish a copy. On a joint request made by the Learned Council for the parties, matter is adjourned to be listed on Wednesday next. Wednesday next is Wednesday
next means date is kitna kiman hai sir? 29th April. 29 April. Yes, my lord. Please furnish a copy to madam. Let her.
I will go to.
Absolutely. And you are also there, Madam Borman? Okay, but role, who will have the role?
Actually, both have the role.
The funds are provided by the center.
Yes, a major part will be provided by the central.
Okay, furnished to both the council. I'll give the repeat because 109 page. No, give the operative part. I'll give this the WPC number from net. They can check mine.
Yes. Oblige.
Item 29.
Kita আছে matter first of all take over na.
We file our affidavit today in this matter.
Yes. Item number
29.
29.
Lordship, we have filed our affidavit today in this matter.
Serve copies.
Yes, Lordship. The clerk. Yes, sir.
Item number 29. Sri K. Jain, Learned Counsel, appearing on instruction of Sri S.C. Kyle, has informed this court that affidavit in opposition has been filed today, which however is not tagged with the records, comma. Sri G. Rahul, Learned Counsel for the petitioner, has acknowledged receipt of a copy of the said affidavit para. In view of the above, matter is adjourned to be listed on Friday next.
No, sir.
Along with the Friday, give the date, along with the affidavit stated to have been filed.
Not the interim order, maybe.
Interim order. Passed early to continue till the next date of listing.
Obliged.
Friday bond hobo na, then put it on Friday kyo mane bond. Actor we'll have it on 4th is also holiday. 4th kyo holiday on 4th of May.
4th of May. Obliged.
Item 40.
May I please, Your Lordship?
Yes.
Lordship,
Ex-gratia, vehicle is identified. So he is not entitled under.
Okay, Justice Surana judgment. Copy. We have passed some similar orders. Heard Sri S. Ayakan, Learned Counsel for the petitioner. Also heard Sri A. Bhachaji, Learned Standing Counsel, Revenue Department, as well as any state council? State council, as well as M. Borman, Miss M. Borman, Learned State Council, para. The claim is for ex-gratia for an accidental death involving a motor vehicle. Both the learned counsel has, however, fairly submitted that this court in WPC
270023.
270023 has passed an order dated
21/6/2024.
21/6/2024 that since the MAC Motor Accident Claims Tribunal MAC Act.
Yes.
MAC Act provides for an appropriate remedy.
ME.
Motor Vehicles Act provides for an appropriate forum for claiming compensation, such compensation would not be covered by the notifications which are relied upon in the instant case. Para. Consider following the same judgment, the instant petition is closed. However, at liberty to the petitioner to approach the concerned MACT if not done in the meantime.
Deeply august.
Item 21.
The order of operator would like to regulate. Justice Surana.
In this matter, no affidavit has yet been filed, Lordship.
Affidavit not filed.
No, Lordship.
This is item number
31, Lordship.
31. Yes, Revenue Department. What is the matter?
My Lord, we are praying for rehabilitation, Lordship. Most of the petitioners had applied for settlement of land. That applications were rejected. And some of us have also been evicted, but we are living in the same area. We are landless persons. We are praying that we may be given some accommodation somewhere, Lordship.
I think your responsibility required.
Well, Lordship may kindly grant sometime.
Heard Sri SD Learned Counsel for the petitioners. Para. Who would be filing? You would be filing Revenue Department. Both Sri A. Bhachaji Learned Standing Counsel Revenue as well as Sri SS Roy Learned State Counsel pray for and are granted 4 weeks time to file the affidavit in opposition. We give a date. List on 25th of May 2026.
Much obliged.
Item 22.
32.
Order number 15/9/25 में kindly be seen. 15/9/25.
In this case,
My lord,
order
yes, sir.
passed by this court.
My lord,
15/9/25.
25.
Okay. Drawn the attention, go to no street, attended to. Yes, any decision taken? Who are you?
I am for the respondent number 3, Lordship, private respondent.
Okay. No, there we had observed that an opinion was there, but no final decision was taken. Have you taken any decision?
Passing of this order, not communicated the system. Today morning also I talked to the authorities. They are saying that they are policy do some materials. So may I take for at least 1 week time In this matter, Lordship, I have not signed my affidavit.
You are for GMC
Yes.
and you are for this number 3.
Yes,
You
Lord.
have filed your affidavit.
Yes, Lordship, I filed our.
Yes, Mr. Saikya.
My lord,
We allow the GMC to file their response or get their instructions.
my lord, a order was passed on 15/9. So they may be given more time, however, because there is the judgment of the full court and the Supreme Court that the unauthorized construction must be demolished. By the GMC, even cost was imposed. I have brought the full court judgment.
Response
of
number
High
3
Court.
has unauthorized constructions.
Yes, the unauthorized.
Hmm?
Construction is unauthorized.
Of response number 3.
Yes,
Who is response number 3?
this my friend is appearing, my lord.
Lordship, we have filed our affidavit and we have denied all the claims of the petitioner, Lordship.
We have submitted the
Are you
reply.
brothers? Your brothers,
No,
not brothers.
my lord.
You are also Kulita, he is also Kulita.
He has been my neighbor, but occupying my own land. We are not on that point now.
Neighbors are more important than brothers. Why do you fight?
No, but disturbing my mother for so many years together, even the revision was filed against the order of
Disturbing you?
145, that revision also was dismissed. That
What disturbance?
Lordship, their title over the land has been settled, Lordship. All the trial court as well as the appellate court as well as the high court had dismissed their claim.
that was this before settlement. After settlement, my lord, it was settled, that land belongs to me.
Why don't you sit and talk and settle this matter?
My lord-
Neighbors, why should neighbors
My
fight?
lord, the construction they have made on my land issue is different. Now, why the unauthorized construction should not be demolished by the GMC? That is the plea, my lord.
Yes, in fact, it appears to be unauthorized because one notice was issued in the year 2023. Asking.
What is your name, Mr. Counsel?
A Singh, Lordship.
Singh.
Yes.
Mr. Singh, if it's unauthorized, wanted to remove it.
Lordship, we have denied it, Lordship. In fact, just a Tin Sali house, Lordship. That is also in temporary nature, Lordship.
So remove it.
As per their claim, Lordship, we have constructed RCC building, but that's not true. We
Remove
have
the
lawfully
tin
purchased
sali,
that
the
plot.
matter will end there. Do you have any photograph, Mr. Saikya?
Yes, my lord, no, they are,
Lordship,
Photographs
we
are
have no
there.
claim over
my
the
lord,
land.
they will dispute that, let them dispute let them file a civil suit. Why
Lordship,
they are
civil suit
silent?
has been
Why
filed,
they are silent against the order of the
Do
GMC?
you have a photograph of the unauthorized construction?
My lord. What is the minimum code?
Now don't go there to have a photograph.
My lord, just a minute. And sir, photographs. Huh? Yes. They have admitted that it is unauthorized construction. But they do not demolish it in spite of the order issued by the GMC. And GMC.
No, Mr. Nayak has said that in terms of the order,
My lord.
you take the instructions what necessary steps are being taken. There is already an opinion of the law officer.
My lord.
Let them take, let him obtain the instructions.
They have issued the notice to them, to the respondent, long back.
That notice is not the subject matter of challenge.
That they did not challenge it.
Then, Mr. Singh, if you have
They
not
did not
challenged the
challenge the order of
proceeding,
the GMC, my lord.
why
They are
don't you
sitting right.
remove yourself and save all the troubles? Otherwise, Mr.
This is the government, my lord, of the honorable. Full
Mr.
court
Nayak,
of-
you have the instructions. Okay. Heard free RC Sekyal senior counsel for the petitioners. Also heard 3 P Nayak, London Standing Council GMC, and 3 S Singh,
S.A. Singh, Lordship. S.A. Singh.
S Singh, London Council for response number 3. Put up while pleadings are exchanged between the petitioner and the respondent petitioners or one attorney petitioners and the respondent number 3, comma 3 Nayak, the London Standing Council prays for some time. Petitioner attire, sir.
Only one.
Why have you written on the? I have Sri Nayak, the London Standing Council prays for some time to obtain necessary instructions. full stop para. In view of the above, matter is adjourned to be listed on. We'll have it on 7th of May,
Fine.
Thursday. Thursday, we'll try to have this matter settled. Then 12th of May, 12 May, Tuesday.
My lord,
12 May, you are around?
my lord. Attempt may be made, my lord, to dispute the-
We'll try to make it.
because the full court has held and impose cost on the respondent and also GMC. Our-
Mr. Singh, instruct your, advise your clients to remove it. If it is unauthorized, no point contesting. Okay, next. Item 33.
My lord, the matter may be passed over for time being, my lord.
Here for whom?
My lord, the petitioner, my lord.
Timing will not be possible today. Affidavit in reply has been filed by you.
Yes, my lord.
Who is your senior?
My lord, Mr. Kibuya, my lord.
Okay. Affidavit in reply has been filed, which has been brought to records list for consideration on Wednesday next.
Obliged, my lord.
Wednesday date.
May please. It is a long history, to cut short, my lord. In 2008 and 9, encroachment notice, eviction notice was issued, my lord. In encroachment case number 1 of 2008 and 2009. That was put into challenge in Board of Revenue. Board of Revenue dismissed this appeal, my lord. Against that, my lord, they preferred a writ petition. Writ petition was dismissed. Then they preferred an appeal, writ appeal. The writ appeal also dismissed with an observation that at page 37, my lord. Have a look on your.
37.
Yes, my lord. After perusing the record, we find ourselves in complete agreement with the view taken by the learned single judge. The appellant must now gracefully accept the order of eviction passed against them by the competent authority and vacate the land if they had not already done so. Now, order was issued by the additional district magistrate, my lord, at page 38. The last third paragraph, however, in the judgment, your lordship got it. No outright order of any eviction carried out by was passed by the honorable court. As the matter had already been.
Who are you?
We are the settlement holder.
Your land was encroached.
We were settled initially 500 biga land. That 200 biga could not handed over because of encroachment. Then the dispute started from 88. It continued below till today. Now the deputy commissioner who instructed the circle officer to evict, that your lordship kindly see the challenge in the Board of Revenue.
Now understood. The encroachers had made the challenge unsuccessfully and it went to the division bench. Division bench asked them to vacate. They have not vacated.
Vacated it and
not vacated.
Not vacated. And the magistrate said, High Court has not directed us to vacate it.
Mr. Roy? At 2, but we need to rise early today. We'll sit for only some urgent matters at 2 o'clock. Okay. Today there is some administrative work. In fact, we did not want to sit in the second half. But we'll sit only for a few urgent matters. Here also take instruction. And where is Mr. Kyle? Mr. Kyle's matter were there. If he's there at 2, otherwise we'll have to fix it on.
No, your lordship, can you fix it any other day?
We can have it any other day.
Next week. No, require some, in one of the matter, I require some interim protection, others.
Then Monday you can have it. Today we have some. We want to rise early.
Either it May 4th.
Monday.
Lordship, we will try at 2, if not then.
No, we do not want to sit at 2 o'clock. There's something very urgent today. We need to
My meeting,
Wednesday.
Wednesday or Monday, when you were,
my meeting will be taken up on 4th of May, my lord. I will-
4th of?
May.
4th May, as photo kito, just as photo ki 4th May. A matter for get us Wednesday, both, ojon.
21, 22 and 23. 3 matters are there.
Dekhila, aru. Okay, you can request our court master. Any urgent matters where interim orders is till today? Is there any interim order till today which needs to be extended? If not, kindly approach our court master. If there is urgency, he'll give it. Okay.